a great class. This is one of my favorites because I like the 27th Amendment one. This is fast paced. We move quickly and we go over a lot. Today, we're going to go over the landmark Supreme Court cases that are in the AP Government and Politics test, the GOPO class. That's what a lot of students call it. They take it in high school. Some students even take it in middle school. And there are questions on that test all about these big Supreme Court cases. Now, students, as we dive into this, remember, you're going to do great. It's all good. It's really about the process of learning the AP class and not about the test. I know that matters to a lot of us, but don't worry about it in the long run. Just the process is going to help you be a better learner in any field that you go into. So you've already won. You've already got the skills. I know that's easy to say when you don't have the test in front of you. But the other thing that I want you to keep an eye on is look at how these cases connect to each other or show opposite sides of conversations, and think about other primary sources that you might be able to connect to it. Because as you're writing the free open questions, it's really great to show comparisons and contrast as well. Tom's going to walk us through the facts of the case. If you have any questions, put it in the chat. We are here to help you. And it's great to see Kansas in the house. It's great to have Warren from Texas in the house. New York is here and near Niagara Falls, which is so exciting. So Tom, lots of court cases to review. Here is the big snapshot of it. They're listed in chronological order. So we're going to go through in general grouping by themes. And one of the big changes this year is that Roe v. Wade is not in the AP quiz or test this year, that they pulled it out. Tom, can you tell us a little bit about what happened with Roe v. Wade and Dobbs, so the students will know why College Board decided to remove that from the questions?
Absolutely. So, Roe v. Wade, it's an important 14th Amendment case dealing with what are known as unenumerated rights. So these are rights that aren't specifically written into the Constitution. In Roe v. Wade, decided in 1973, the Supreme Court said the Constitution protects the right to reproductive choice. But in a decision last term, Dobbs versus Jackson Women's Health Organization, the Supreme Court overturned Roe v. Wade and said that that protection is not actually written into the Constitution.
Great. So again, there'll be open questions where you may be able to weave this in, which is why we think it's important to share it with you. And it's just good to know about this, how court cases are established, what is the opinions and dissents sharing, and how does it affect other cases from the past. So we're going to look at these through these groupings. And so we're going to begin with the design of the Supreme Court and judicial review. That's the big idea behind our first case. And when we look at the AP government framework, the big concept that they want you to be able to talk about when using this case as evidence is the design of the judicial branch protects the Supreme Court's independence. So thinking about separation of powers, thinking about checks and balances, how does the design itself of the independence branch and how it's been determined over time by court cases like this next one help to explain how the court can stay independent as an independent branch of government, and emerge is the idea of judicial review. And that remains a very powerful judicial practice. So Tom, tell us the story of the case, and then tell us kind of how we should understand judicial independence and judicial review.
Absolutely. So Marbury versus Madison decided in 1803 by the Marshall Court led by John Marshall. Again, sort of the really, really big takeaway we get from Marbury versus Madison is that it affirms the power of judicial review. This is the power of courts to review actions taken by the government like laws and decide whether they're constitutional or unconstitutional. The case itself grows out of a pretty amazing cast of characters. We have the founding generation's frenemies there with John Adams, Thomas Jefferson. We have the father of the Constitution, James Madison. On the left here, this person that no one probably knows about, William Marbury. But he's at the absolute center of this case. So John Adams is leaving the presidency. At the end of his time in the presidency, he grants a post to William Marbury to become what is known as the Justice of the Peace in Washington, D.C., but they don't deliver him the piece of paper that gives him this commission, so he can't take the job. And Thomas Jefferson and James Madison, the new president, comes into office and says, I'm not going to give William Marbury that position. James Madison do not deliver this commission to William Marbury. William Marbury goes to court and eventually it goes to the Supreme Court. And he says, court, I was given this job you need to order the president and you have to order James Madison as Secretary of State to deliver this job to me. And John Marshall steps in, and what he says a few different things. He says, one, William Marbury, you have a point. You do actually have a right to this particular position. Two, Congress has even given us, the court, the power to force the Secretary of State, James Madison, to give you this job. But we, the court, also have the power of judicial review. And when we look at that law that Congress passed granting us that power, we say it's unconstitutional. So we do not have the power to force James Madison to deliver you this commission. This is John Marshall on the one hand saying, no, we can't take this power Congress gave us. But on the other hand, coming in and saying, but we do have this power of judicial review.
Fantastic. And I really appreciate the teachers in the chat that are also sharing other tips that they have found over time from when their students have taken the AP test. You keep doing it. It's really helpful to know and to share in there as well. Now, our next grouping are two cases around federalism. So this idea that federalism reflects this dynamic interplay between the powers of the state and the powers of the national government. And again, students can bring up the idea of separation of powers here as well, that our Constitution doesn't just spread out powers across the three branches, it spreads it out also between the national government, the state governments, and technically the local government as well. So really thinking about the distribution of power and why. So Tom, maybe take one beat on federalism and why they did that, because that's such a good point to make when talking about these cases.
Yeah, so federalism, it is this division of power between the national government and the states. It is asking the question of which powers does the Constitution grant to the national government? Which powers does it leave with the states? And in part, the vision of federalism was that we think that there are certain things that are big national responsibilities. That's part of why we created this new Constitution. But on the other hand, the founders also believed that state governments were the governments that were closest to the people. We know that Americans are a diverse people, and they wanted to give the people the power at the state level to shape really important policies on a range of issues. They wanted an important role for the states even after the ratification of the Constitution.
Awesome. So now let's dive into these two cases. Tell us about McCulloch v. Maryland.
Sure, McCulloch v. Maryland, it's decided in 1819. It's still part of the Marshall Court, a decision written by Chief Justice John Marshall. It involves a conflict between McCulloch, who's an official of the Bank of the United States, and the state of Maryland. And so McCulloch v. Maryland is bringing in one of the big constitutional debates in early America, whether Congress has the power to pass a national bank. And what Maryland has done here is Maryland has used its own power to pass taxes, state taxes, to effectively try to tax the national bank out of existence in Maryland. And the question is, there are really two big questions here. One, can Maryland do that? And two, the bigger question is, did Congress have the power to pass a national bank in the first place? What Maryland says is, the lawyers there say, I picked up my Constitution. I don't see anything in the Constitution that grants Congress the power to charter a national bank. There's no charter bank clause, case closed. And what the Supreme Court does is it steps in and Chief Justice Marshall says, no, Maryland, you're not reading the Constitution the right way. In the end, sure, the Constitution grants Congress certain powers under Article 1, Section 8, like the commerce power, like the power to tax and spend for the general welfare. But there's also a key provision known as the Necessary and Proper Clause. And what this clause tells us is that there are also going to be certain specific powers that Congress has that aren't written clearly in the Constitution, that we can imply those powers, though, from the powers that the Constitution does grant Congress. So a power to charter a national bank is related in an important way to powers that Congress does have, like the power to borrow money, to tax and spend. And so here's the key language from Chief Justice Marshall. He says, let the end be legitimate, let it be within the scope of the Constitution and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution are constitutional. So McCulloch stands for the idea that Congress also has some implied powers that aren't specifically written in the Constitution.
Fantastic. And now the next case on this front is a more modern case, modern-ish is what we like to call it, around the Commerce Clause. So tell us a little bit about the Commerce Clause on this front.
So if McCullough seems to be saying that Congress has broader powers than you might think initially looking at the Constitution, United States versus Lopez is in here to remind us that the Constitution still creates a national government of limited powers. And so United States versus Lopez is about setting certain limits on Congress's power under the Commerce Clause. And so what happens here is Alfonso Lopez is a student. He's arrested for carrying a concealed weapon in his high school. He ends up being charged under the National Gun-Free Schools Act of 1990, which was a law passed by Congress banning individuals from possessing firearms near schools. But Lopez steps in and says, look, this law passed by Congress doesn't have the power to do it. Congress said that it had the power to do this under its commerce power, but what does carrying a gun into a school have to do with commerce? So Lopez is effectively arguing Congress is exceeding its powers under the Commerce Clause. And the Supreme Court steps in a 5-4 decision written by Chief Justice Rehnquist and says, Mr. Lopez, you're right. This particular law does extend beyond Congress's powers. It's a non-economic activity. It's a sort of thing that you would expect state and local governments to usually regulate. And so this ends up being an important case for setting certain limits on the commerce power of Congress.
And when we're talking about these cases, Tom, there's a lot of in between. Like, it's not just this case and this case. These are like the bookend cases. So are there any other cases along the timeline that students could reference in their comparing cases? Or I always think of like Wickard v. Filmer and this one together, because it's almost like the high and the low of these rights. But could you share a few cases that might work?
I mean, I think Wickard is probably the best example. I mean, the big thing to realize about Lopez is between 1937, so during the New Deal, and 1995, when Lopez is decided, the Supreme Court doesn't strike down any laws as exceeding Congress's commerce power. So the Supreme Court, for a long period of time, for decades upon decades, read that power really broadly with few limits. And Lopez is stepping in here and saying, sure, we're not going to overturn Wickard v. Filburn, which says that Congress has broad power to regulate a farmer from planting crops on his own land that he's not bringing to sale, but we're not going to extend it beyond that, and we're going to reaffirm that there are limits to Congress's power, so we're going to step in and strike down this law as unconstitutional.
Perfect. Okay, so the next section we're going to dive into is all around the Bill of Rights, and thinking through these ideas about the continuous interpretation of the Bill of Rights and the balance of power between the government and individuals. And that's really what the College Board wanted to get out in this section of cases, is like, how do we understand, the power of the government, the power of the individuals, and not always put them at odds with each other too. Sometimes it's about, how does the government help the individual rights and the civil liberties? So can you unpack some of these cases for us?
Absolutely. Should we start with Engel versus Fattal, 1962?
Yes, that sounds perfect.
Excellent. So this case is dealing with the First Amendment's Establishment Clause. It's decided in 1962, 6-1 decision, the opinion written by Justice Hugo Black. And here, the New York State Board of Regents, it authorizes public schools to recite a short voluntary prayer at the beginning of each school day inside the public schools. And a group of parents then challenge this practice as violating the Establishment Clause. And in the end, the Supreme Court strikes down the New York prayer under the First Amendment. The court explains that state officials can't compose official prayers and require that they be recited in public schools, even if the prayer is quote unquote denominationally neutral. So even though it's not pushing a particular branch of religion, and even if students could opt out of reciting the prayer. So it's a broad statement about the limits of school prayer inside the schools.
Great. And we're going to keep cruising through. Wisconsin v. Yoder, also another one of my favorites.
Yeah, so this is the other religion clause. This is the First Amendment's free exercise clause. And what happens here is that Wisconsin passes a compulsory education law. So requiring kids to go to schools up past the age of 16. The Yoder family, they are Amish. And so they step in and they say that Wisconsin's requirement here violates their free exercise rights under the First Amendment. Why? Because we in the Amish faith, we're okay with sending our kids to public school up until our kids hit 8th grade. But after that, they're going to start learning values that are useless to them within our religious community. And they're also going to undermine the values of our community. So we should not have to send our kids to school. This law shouldn't apply to us. It applies to everyone else, but it shouldn't apply to us. We should get an exemption because of our religion. It shouldn't apply to us because of our religious beliefs. And the Supreme Court, in a decision by Chief Justice Berger, said, yes, Yoder family, you're right. And so it grants the religious exemption in this case.
Now, the third case, and these aren't, I promise people, these aren't all just student cases on the Bill of Rights, but these three are. The third case in this set of five is Tinker v. Des Moines, one that a lot of us know really well, but why is it so important that it's in the framework?
Absolutely. So this is a case in 1969. It involves students, as you can see in the picture here, who are wearing black armbands to protest the Vietnam War. Their school punishes them for wearing those armbands inside the school, and the students and their parents go to court and they challenge it, saying that them being punished for this particular act of wearing the armband violates their First Amendment free speech rights. Effectively, they're saying, we may not have been speaking words, but this is a form of symbolic expression. We didn't disrupt the school day in any way, and we're speaking on really broad issues, important issues of public concern. And the Supreme Court steps in a 7-2 decision written by Justice Abe Fortas and says, yes, Tinkers, you're right. And so it says the school cannot punish them in this context. Importantly, it says that students and teachers, they don't shed their First Amendment rights at the schoolhouse gates. They still have them. The sub point here, though, is that free speech rights work differently inside the schools than elsewhere. So the court does also say that schools can step in and regulate speech if it's likely to materially or substantially interfere with the school's operations. So there are ways in which school officials could step in and curb speech in a way that we couldn't out in public discourse if it's really serving the educational mission of the school. But Tinker itself, the Tinkers win. They were able to wear the armbands, they're able to protest the Vietnam War without materially disrupting the school operations.
And not to be a super nerd here, but I'm going to do it for a second. We're opening a new exhibit on the First Amendment at the end of June of this month in Philadelphia at the Constitution Center. And I hear Mary Beth Tinker is going to have a little cameo in the exhibit. Is that true, Tom?
Yes, and we'll also have one of the armbands in all likelihood.
Even cooler. Okay, people, if you're in Philly in the summer, please come visit us. Okay, two more cases around the idea of the Bill of Rights, a lot of these First Amendment cases, and these are not in school classrooms. So we're going to look at New York Times versus United States, and we're going to look at Schenck. So pull in any other cases that can be complementary to this as well, Tom.
Absolutely. So just beginning with this case here, New York Times Company versus United States, decided in 1971. It's also known more famously as the Pentagon Papers case. And so this case covers speech at the core of First Amendment protections, speech on public concern. It's about the Pentagon Papers, which were a study done by the Department of Defense about U.S. involvement in the Vietnam War. We had someone, Daniel Ellsberg, worked at the Rand Corporation. He knew about the report, and he sat there and photographed 4,000 plus pages of these Pentagon Papers, sent them off to a reporter for the New York Times. The New York Times began publishing it. The Nixon administration steps in and says, stop the presses. You cannot publish this information. It's vital to national security. It's going to harm our national security interests. And the court said, no, Nixon administration, you're wrong. And what the court does here that's really, really important is it affirms one of the big principles at the core of the First Amendment, which is that there's a preference, there's a core rule under the First Amendment that we're not going to have what are known as prior restraints. And so what that means is that generally speaking, the government can't step in and tell someone not to publish something. Once you publish something, you might be punished for what you published if it violated the law in some way, but we don't want that form of government censorship. If the government wants to step in and stop the presses, they need a really, 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 really good reason to do so, and they didn't have it here.
And then the Schenck case.
Sure. So Schenck, it's decided in 1919. So it's in the context of World War I. It's an important First Amendment free speech case. The defendants here were charged with mailing printed circulars designed to obstruct the military draft during World War I in violation of the Espionage Act of 1917. The Espionage Act made it illegal to, basically send out information that was undermining the war effort. And the question was, does this law violate the First Amendment free speech rights of Schenck and his colleagues? And the Supreme Court, in a unanimous decision written by Justice Olive Wendell Holmes, says, no, Congress doesn't violate the Constitution. This law is constitutional. These convictions of these defendants for violating the Espionage Act of 1917, they're fine. They're fine. We're going to uphold them. And what this case does in important ways is it tells us that the First Amendment protections, they may be broad, but they're not absolute. There are limits on them. And the famous quote here is from Justice Oliver Wendell Holmes, where he says, the most stringent protection of free speech would not protect a man and falsely shouting fire in a theater and causing a panic. So again, there are limits to free speech rights. He also sets down the important clear and present danger test in this case. The last thing I'll note, Curry, though, is that this is an example of, a pretty a narrow view of free speech rights in the context of wartime. What we'll see as we move further and further into the 20th century is that the Supreme Court commits to a much more robust vision of the First Amendment across a range, First Amendment free speech across a range of cases, culminating in a case known as Brandenburg versus Ohio, which was decided in 1969, which set a really, really broad speech protective rule that, generally speaking, government can't regulate speech unless it's directed to inciting or producing imminent lawless action and is likely to produce such action. So we end up having, although Schenck talks about the limits to free speech rights, today in America, we have the broadest free speech protections we've ever had in our nation's history, and among the broadest free speech protections in the entire world.
And that's basically Tom telling you that's a really important case, that's the Brandenburg case. So pay attention to that. And I think it's really interesting. This is why we supported the College Board in reviewing and writing this framework, but it was really hard for us to say this case over that case, this one over that one, because they're like pieces of a puzzle almost all the time that go together. And so when you only look at one case, you don't get the full story, you don't get the full view of the rights in our country and the struggles for these rights over time. Now that leads us perfectly into these next two cases that are looking at incorporation. So this idea that the 14th Amendment incorporates the Bill of Rights to the people within the states. And really, I like to call the 14th Amendment the sticking amendment. It makes the Bill of Rights stick to the individual. These two cases were chosen to show a little bit about selective incorporation. But the first case, the Gideon case, is going to look at how were criminal procedures ensured for the individual. And the second one is going to look at the Second Amendment and gun rights. So again, neither of these two would you look at it in isolation for incorporation, where they're just two good stories around how that worked and procedurally. So students, as you're examining these other cases and thinking through the connective tissue between them, make those points, because that really shows your ability to analyze and process and apply instead of just learning all the facts about one case. So Tom, walk us through, again, another one of my favorites. I love the Gideon case. It's such a powerful story of the individual sticking up for their own rights and forcing the Constitution to change to suit what is more perfect.
Absolutely. So Gideon versus Wainwright involves Clarence Earl Gideon. So he is arrested, tried, and convicted for the burglary of a pool hall in Florida. So this is a felony count. But Florida denied him an attorney under Florida law and provided counsel. Florida only provided counsel to like death penalty defendants and things like that, not even felony defendants. Gideon goes to jail. He becomes a jailhouse lawyer of sorts, reads the law, reads his Constitution, and he says, you know what? I think my constitutional rights were violated. I read my Sixth Amendment. I have a right to counsel. Why wouldn't that apply in this situation? And so, on a scrap of paper in his jail cell, using a pencil, he writes a petition to the Supreme Court saying, "Take my case." And so it ends up before the Supreme Court. The justices see the petition. They grant Clarence Earl Gideon's case, and in the end, they side with Gideon. And importantly, in this case, what they do is they incorporate the Sixth Amendment's right to counsel against the states, such that defendants like Gideon in Florida and in states throughout the nation would have to have a right to counsel.
I love that story. We could talk about Gideon all day. It's amazingly powerful. Now, McDonald v. Chicago, which so many people, when they're thinking about cases around the Second Amendment, they always think of Heller. And I feel like McDonald v. Chicago doesn't get a lot of conversation. So could you talk a little bit about why this case was chosen for this topic, and then maybe just a beat on Heller?
Sure. So McDonald versus Chicago, the big picture here is that it incorporates the Second Amendment's protection of an individual right to keep and bear arms against the states. And so in part, it's in the framework, I think, to remind us that this process of selective incorporation, of looking at Bill of Rights protections, and deciding whether to incorporate them against the states, it's still ongoing. You know, this is 2010. There have been other cases since then also dealing with incorporation. So we see that with McDonald. You know, the other thing is that it's a weird quirk of American constitutional history. The Supreme Court really didn't decide major Second Amendment cases until really District of Columbia versus Heller in 2008. It decided a few, but none of them were really big, massive rulings. But in 2008, the Supreme Court decided District of Columbia versus Heller, where it struck down a DC handgun ban enacted by the federal government as violating the Second Amendment. Washington, D.C. is not a state. It's a federal territory, so you don't need incorporation for the Second Amendment to reach there. But what the Supreme Court said is that the Second Amendment protects an individual right to keep and bear arms for the self-defense of one's home. And the question in McDonald then was, does that protection, that Second Amendment protection, should it then be incorporated against the states? So we see a constitutional challenge to a similar handgun ban in the city of Chicago. And then in a 5-4 decision, what the Supreme Court says is, yes, we are going to incorporate that protection of the Second Amendment that we recognize in District of Columbia versus Heller against the states. We are going to protect an individual right to keep and bear arms in states throughout the nation against abuses by state and local governments.
Awesome, Tom. Thank you. And now Mark has a great question. It's the classic question. These are two examples of what has been incorporated. When thinking about the Bill of Rights overall, what has not been incorporated by the states in the Bill of Rights?
Yeah, there's not many examples. The Third Amendment, so the protection against quartering of soldiers, has never been incorporated by the Supreme Court. There aren't a lot of quartering of soldiers cases, so that that could be part of the reason why. Another is that the Constitution's protection of grand jury rights, that grand jury protection has not been incorporated against the states, and also the Seventh Amendment's protection to a jury trial in civil cases has not been incorporated against the states.
Fantastic. Great. Equality is our next big section. And so when we're looking at this section here, we're looking about the 14th Amendment's Equal Protection Clause. So tell us a little bit about the Equal Protection Clause, and then this case, and probably Plessy versus Ferguson, and how they're connected about advancing equality for all.
Yeah, so the 14th Amendment writes important protections for the equal protection of the laws against the state. So it's trying to attack state and local government abuses of the equal protection of the laws. Brown versus Board of Education grows out of a long-term, decades-long litigation strategy by Thurgood Marshall and the NAACP Legal Defense Fund attacking Jim Crow laws inside the schools. So it's attacking school segregation laws that separate white students from black students into different schools. In a case known as Plessy versus Ferguson in 1896, the Supreme Court upheld the doctrine of separate but equal, so said Jim Crow is consistent with the Constitution. In that case, it was dealing with a law dealing with transportation on streetcars, but here we're dealing with segregation inside the schools. And the Supreme Court in Brown versus Board of Education in 1954, in a unanimous decision written by Chief Justice Marshall, struck down school segregation and said that it violated the Equal Protection Clause of the 14th Amendment. Here's the famous quote: "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." Effectively, the court saying we were wrong. Plessy v. Ferguson was wrong the day it was decided, and now we are going to finally enforce the promise of the Equal Protection Clause.
And with this case, and we're thinking about like the two big names on the court side of this, like I always think about, this is like my favorite picture ever, because it's just a young girl trying to go to her school and her mom, who are really the powerhouse behind this case. But when we think about the court, who's the head of the Supreme Court at the time, and then who's that famous attorney? We should know his name.
Absolutely. So, I mean, it's written by Chief Justice Earl Warren, who was one of the most important justices ever in Supreme Court history. And the key lawyer is Thurgood Marshall, who was the lawyer for the NAACP Legal Defense Fund and would go on to become the first African-American justice of the United States Supreme Court.
It's just a blockbuster case on this one. And again, so many cases that lead up to this one as well. Now, this next section we're going to look at is looking at elections. And we're going to talk about campaigns and electoral rules. But Tom, could you also weave in here, we'll go back to federalism that we talked about in the earlier cases, just in case students want to connect the dots between different cases and say, why did we separate the powers and how do elections work? And then when does the federal policy come in and kind of level the elections as well? So I know that's a little bit of a jump between that theory and this case, but if you could marry those two together, that would be great.
Yeah, sure. So under the original Constitution, the Constitution leaves many issues when it comes to elections and voting to the states. So importantly, election and state election laws and voting laws are largely governed by what states choose to do. There's a great deal of power there, but there are also powers in the Constitution granted to the national government in this context. Under the original Constitution, Article 1, Section 4's election clause does give Congress the power to step in and regulate the time, place, and manner of elections. And then one of the great themes of constitutional reform throughout American history is the expansion of voting protection to more and more groups like the African Americans with the 15th Amendment, women with the 19th Amendment, those 18 years of age and older with the 26th Amendment. And each of those amendments grant Congress power to enforce those protections, so giving Congress more power than it had before in the context of elections and voting.
Fantastic. Now, you want to jump into Citizens United?
Absolutely. Citizens United versus FEC. It's an important election law case. It's also an important First Amendment case. And so the Federal Election Commission tries to apply a congressional law, the Bipartisan Campaign Reform Act, to a film produced by Citizens United known as Hillary the Movie, when Hillary Clinton was running for president in 2008. The movie was funded in part from funds from the general treasuries of corporations. And the FEC is arguing that that sort of funding violates Congress's ban on political spending by corporations and labor unions in partisan communications during elections. And in the end, the Supreme Court in a 5-4 decision says, no, you can't place those sorts of restrictions and place bans on political communications placed on corporations or labor unions. Those are unconstitutional. They violate the First Amendment. Why? In part, it's a broad reading of the First Amendment providing a space for a whole range of voices to speak during campaign season, including often unpopular voices like unions, like corporations. But broadly, it's an endorsement of sort of broad free speech protections.
And I appreciate you connecting this election and federalism with the free speech conversation earlier as well in the Bill of Rights. So perfect. Thank you for that, Tom. Now, these last two cases in my brain, I always think of them as election cases. And it really comes back to this idea that representation matters. And some of these battles do come out in looking at how your vote counts and what the ways that your vote counts within your state and your legislative groups. But also the same idea is bring it back to the big concept under the Constitution of a republic. We are a republic, and how that manifests itself, and then the representation through that process. So can you give us that big setup, and then we'll dive into Baker v. Carr and Shaw v. Reno?
Yeah, so I mean, our government, our Constitution guarantees a Republican form of government in the states. And both of these cases have to do with how we draw district lines to determine what voters are electing which elected officials, whether it's state elected officials or officials in Congress. And so Baker versus Carr is an important, these are known as legislative reapportionment cases. But again, it really just has to do with how we draw district lines in the states. Why is this important? In part, it's because if you have different districts with radically different numbers of people in them, some people's votes effectively count more than others. And so Baker v. Carr was decided in 1962. It was a really, really important case. It's dealing with state legislative districts drawn in Tennessee. The Tennessee legislature established those districts 6 decades earlier. They didn't decide to redraw those districts at all in that 60-year period. During that period of time, the population really shifted in Tennessee, largely away from rural areas towards urban areas. And by not rebalancing the districts, you are effectively giving more political power to rural areas than to urban areas. The question the Supreme Court had to say is, do we have any power to step in and decide a case like this? The Supreme Court earlier had said, no, we don't. This is the sort of question that's a political question that we really don't have the tools to answer or the constitutional authority to answer. The Supreme Court here steps in Baker v. Carr and says, no, we were wrong. And so in a 62 decision by Justice Brennan, the court says, yes, we do have the power to hear and decide legislative reapportionment challenges under the 14th Amendment's Equal Protection Clause. And so this then tees up later decisions like Reynolds versus Sims just a couple of years later, which established the important principle of one person, one vote. So the general idea that the 14th Amendment's Equal Protection Clause requires legislative districts to be roughly the same size.
Fantastic. And Tom, you're making it through all the way to the end. Shaw v. Reno.
Okay, so Shaw v. Reno decided in 1993. It has to do with the issue of racial gerrymandering. So gerrymandering is the idea of using certain often inappropriate factors to decide district lines and decide which voters go where. Racial gerrymandering has to do with the use of race to decide the composition and the structure of districts. And so the question is, what does the Constitution have to say about racial gerrymandering? Here in this case, this is the map that was at issue. North Carolina creates a congressional reapportion map that creates 2 majority African-American districts. One of them is an unusual shaped district designed to track Interstate 95. That's the pink one in the middle of the state there, where it's just sort of like a kind of a snake of sorts across the interstate highway. And we have residents in North Carolina then challenging this oddly shaped district under the 14th Amendment's Equal Protection Clause, basically arguing that North Carolina designed this district taking race too much into account, and that has to be closely scrutinized. In a 5-4 decision, the court concludes that while North Carolina's plan wasn't expressly based on race, when we look at the shape of the district, it's so extraordinary that we have to infer that it could be that the state may be using inappropriate factors like race in deciding how to draw it. So if we see, basically, it's kind of a weird case, but it's like if you end up seeing a district that seems sort of oddly shaped like this, that it's going to trigger the court to then closely scrutinize that decision by the state and ask the state to come up with a good reason of why they drew the district that way. Maybe they had a really great reason that didn't have to do with race, but the state has to be able to give it. More broadly, though, what the court's saying is we are going to closely scrutinize the use of race when it comes to reapportioning districts. We don't want race, we don't want race to be the predominant and overwhelming factor when drawing district lines.
Fantastic. Tom, that was great. Everybody, you made it till the end. One really great question from Mark that parse it out for us, Tom. So a Republican form of government and representational democracy, how are they connected, subsets, different? Explain the difference between the two or the similarities.
Yeah, I read them mostly together. I think that republicanism is mostly contrasted with direct democracy. And so direct democracy is the idea of just everyone voting on everything. An assembly that just comes together and votes on everything. But once you have a big enough polity, if you want to have anything approximating government by the people, you're going to have to move to a Republican form of government. What that means is representative democracy. It means you're voting for elected representatives to represent your interests. There are all sorts of other big components of a republic, but that's sort of the most essential one, is that the idea of representation and elected officials that are there to represent you.
Great. Awesome. Thanks so much, Tom. That was fantastic. Everyone, you did a great job, and best of luck to you all on that AP exam. We were sharing our bad test taking behavior earlier. You will do great. You remember, again, it's the skills you've built to now that actually will be the life skills that you need, not just the test and the test score at the end of the day. So Tom, thank you so much for walking through everybody. Students, thank you so much for sharing ideas. And I promise I will send you all the cheat sheet notes that we have out to everybody as soon as we're done class today. So if you want to cram and read them over again, you can do that. And you can always email us and we can see if we can help in any way possible. So thanks so much. Tom, I wonder if we took the test, how we would do.
Good question. I don't know. I'm thinking back to my old AP government teacher, Mr. McCoy, who was one of my great teachers in high school.
Yeah. Oh, I love my AP Gov teacher. He was my favorite. Very cool. Students, great. Best of luck to you all. Tom, thank you so much. And have a great day, everyone. Bye.
All right. Bye, Corey. Bye, everyone.